SJC-12119, Padmanabhan, v. Board of Registration in Medicine.
Dr. Padmanabhan, give us 1 second, and then we'll let you commence. And you may proceed.
Good morning, Chief Justice. Good morning, Associate Justice. I'm Dr. Barani. That's how everybody calls me. Unless my mother is angry, nobody really uses my full name. I'm a neurologist. I've been in Massachusetts for 20 years. And for the last 6.5 of those years, I have been pursued by the Board of Registration in Medicine, an executive agency. The docket against me started in November of 2010 as a result of a false report from a hospital where the chief of neurology, Dr. Glick, and I had done a small study as a quality improvement project, and we found patient neglect, insurance fraud, and so on. So he was pushed into retirement, and I was thrown out, and a false report was sent to the board. The hospital held its own fair hearing, and I was fully exonerated by the hospital's own fair hearing panel. They said, no credible evidence to suspend his privileges or terminate him. So I presented that evidence to the board along with the sworn transcripts, and nothing happened till about January of 2013. In the meantime, the hospital hired an external agency called the Greeley Company to rehash the old accusations and present it as a fresh report called the Greeley Report, which remains anonymous and unsworn to this day. So in January of 2013, the Complaints Council of the agency, the board, quoted verbatim from this Greeley report and called it his independent investigative result done through the taxpayers' dollars on behalf of the people at that agency. So I stood up and said, this is verbatim from a report paid for by a hospital. This is unfair. It violates due process. And so the board never touched my license. In fact, my license has never been touched to this day. Every 2 years, I renew it routinely. However, since there's an open docket at the board, I am unable to get employed. And since there's an open docket at the board, I'm unable to get reimbursed by insurance companies because there's this process called credentialing, where every 2 years you sign up with an insurance company to be allowed onto their rolls and to be allowed to see their customers, to their insured population. So I have been seeing my patients for the last 6.5 years entirely for free, because I've been unable to get reimbursed. So I'm still here. I still have an active license, but I can't get paid. And my patients are wonderful. They've stuck with me these 6.5 years, and they've repeatedly written to the board and come and testify to the board saying, end it, end it, end it. There's no case here. But they've been ignored. We went through a second trial at the board in January of 2015. This trial was at Dala with an administrative law magistrate, 8-day hearing under oath with a court reporter, the whole works. In August of 2015, that magistrate issued a report, the tentative decision or initial decision as it's called under 801 CMR, and said no evidence for substandard care, no discipline warranted. So according to 801 CMR, which is really one of the two main questions before this court here today, the agency had 180 days from August 7, 2015 to reject, accept, partially accept, whatever, but issue its own final decision. February 3rd, 2016 came and went. The agency had not issued a final decision. So I sent a letter to the agency saying, according to the law, it's over. The magistrate said no discipline warranted. Roll it up, please. Take your ball and go home. Close the docket so at least I can get hired. I can get paid because I haven't been able to get paid for 6.5 years.
So was that in February, did you say?
February 2016, February
And so
3rd.
the order indicating that the magistrate was preparing a revised recommended decision in response to a remand order did not happen until March 2016?
It did not happen until August 30th, 2016. That's when he actually issued a second decision.
And what does that decision say?
That second decision said, I assume that correct diagnoses are the standard of care, and therefore, since there was, according to the board's expert, an incorrect diagnosis, therefore I assume that there was substandard care.
So this is a finding that's adverse to you for the first time, is that what you're saying?
It was a finding that was issued after the 180-day deadline had passed,
Right,
without a final decision.
but in this decision, this is adverse, and what is the result
Not only
of
was
this?
it was adverse in a way that was completely counter to the dictate of 801 CMR, which specifically said the agency cannot question the credibility determinations of the hearing officer. And if you read the remand order, it says very clearly, the board respectfully requests that the magistrate include credibility determinations in the recommended decision. Acknowledge the written expert reports the party submitted and comment on the weight he gave to them. 801 CMR explicitly prohibited them from doing that. He issued a recommended decision that was completely opposite to his first one, but hewed completely to the desired outcome of the board. So what you have here over 6.5 years is this campaign where the board was hell-bent on damaging my professional reputation, damaging my professional license record. Anytime I presented enough evidence to show that they were wrong, it was ignored. The first decision that was released by the hearing officer was against their goal of harming me. They ignored it. The 180-day deadline passed in February 3rd, 2016 without a final decision. They ignored it. The whole point was to get me, the law be damned. And that's really why I came to this court to seek relief. This court has actually issued a very nice decision in just 2013, not very long ago, in McGuinness versus the Department of Correction, where this court, in a precedent-setting decision, because nobody had ever addressed this question before, said very clearly, 180 days passed, no final decision. The tentative decision became final by default, period. Case closed. So I'm here today to ask this court to maintain that decision from 2013 and apply it to my case. February 3rd, 2016, the tentative decision became final, case closed.
But
The-
I gather that within, I mean, my understanding is that the Dala magistrate did the recommendation in August of 2015, and then in January 2016, they sent it back to the magistrate.
Correct.
So you're saying that, that's of course less than the 180 days, but you're saying that if the Dala magistrate does not issue new findings within 6 months, the old findings,
Correct. That's what 801 CMR clearly says, and that's what this court ruled in 2013. When they remanded it back to the Dallas magistrate, it was his obligation to return an amended decision, if he so choose, before February 3rd, 2016. The whole point of 801 CMR's 180-day deadline, and by the way, it's a misnomer, I'll get to that. The whole point of a 180-day deadline is to provide closure to people. So we're balancing the individual's interests and rights versus public interests and rights. And 180 days was adjudged by the Department of Administration and Finance, which is, obligatory on all departments in this Commonwealth, not just the Board of Medicine, to be a reasonable accommodation. 180 days is enough to figure out if this person is a danger or not. 6 months is a very long time. The 180-day clock for this started on August 7, 2015, which already was 5 months out from the end of the Dala hearing, which ended in March 9th, 2015. So the 180-day clock itself started 7 months after the hearing was started. So we're already 1 full year into this whole trial process. We're already 5 years into the whole docket. So it's a huge amount of time for any agency to collect enough evidence to say, this is a bad person, this is a bad doctor. Reality is, I'm an excellent doctor, world class. No one had ever, in any fair proceeding, found any evidence against me. What they did was they went and coerced a magistrate to change his decision from black to white after he lost jurisdiction to do so. His jurisdiction ran out February 3rd, 2016. And that is exactly what this court has decided in McGinnis versus DOC. Therefore, the second amended decision from August 30th, 2016 must be declared to be null and void. The other issue which I presented to the court was the issue about the
I'm afraid you've got only 10 seconds, so why don't you?
Massachusetts Controlled Substance Registration Certificate issue, which was fully briefed. The board had written in its red brief that I never approached this topic at all in the lower courts. I just want to mention that it's not true. It was in my original complaint to the single justice court and in every document ever since.
Okay, thank you, Doctor.
Thank you.
Mr. Furgang?
Morning, Your Honor. Samuel Furgang for the board. This is the second time that Dr. Padmanabhan has attempted to forestall the disciplinary proceedings of the board by way of filing a petition for certiorari. The first time that was dismissed by Justice Botsford. The second time it was dismissed by Justice Spina. In both cases for the same elemental reason, which is that a petition for certiorari is not the appropriate vehicle for relief when there is an alternative adequate remedy.
But it doesn't exist until they're done with what you're going to do, right? It's not until you've granted a final order, right?
Your Honor, there has not been a final order.
Right, in 5 years, there hasn't been a final order? Or more than 5 years?
Well, the process is, well, my understanding is that the statement of allegations first was brought out in 2014. So the timetable is a little more truncated than that.
Still, it's a long time.
It is a long time, Your Honor. It's within the time scope that the rules permit.
And how long do the rules permit?
In terms of the only timeline the rules provide for is a 180-day time limit for the board to act upon a tentative decision.
Yes, but in reality, this is a lot longer than 180 days.
Yes, Your Honor, because a lot has transpired in that time. First of all, the board, of course, has no control over how long it takes the magistrate to issue an opinion after a hearing. It also had to deal with the initial petition before the hearing even took place. That forestalled the actual hearing. The hearing began 3 days after that first petition was dismissed. And that was back in, I believe, March of 15th. The dismissal of the first complaint took place in January the 9th. The hearing began on January the 12th and took place over 3 months. The decision didn't come out until August the 7th. And again, the board had no control over the time it took for the tentative decision to issue. Once that decision is issued, then the board invites comment from both sides and ponders over that. It then requested on January an order of remand, as the court pointed out, within 180 days. Under the rules, once that order of remand is made and it's recommitted to the magistrate, the clock begins again for another 180 days after the next decision is issued. When that decision was issued, again, the board had the opportunity again to make comment within 180 days before it becomes final. This case was filed before that second round even occurred. So we're faced with a situation where the board requested additional findings within 180 days. This suit was filed based upon the claim that because a final decision had not issued, or rather the complete decision had reissued, that the court should recognize the first one. Under the rules, that's simply not the case. It provides for the option for a recommittal for additional findings. That is what took place here. And again, this is a situation that is a procedural concern. It could have been raised in the course of a normal appellate procedure under 30A or 112, depending on what the ultimate resolution of the board would have been. But instead, the appellant chose to go straight to the SJC via a petition for certiorari, and that is simply not the appropriate procedure.
So is there any limit? Can you send it back to the magistrate again for more findings, and then send it back again, and ultimately have this process be never-ending?
Well, that question, as far as I can tell, has not been addressed. I don't know that it's ever come up before. I'm sure, as a general concept, there must be a limit at some point, but the rules do provide, at a minimum, for at least one recommittal. It's very specific about that. And that's all that we're faced with here today, simply one recommittal. And that is now pending. So given that, there's no basis for interfering in the normal course of the procedure undertaken by the board, and if the appellant is dissatisfied with the ultimate resolution with normal appellate process via the Superior Court, or if it's a dismissal to this court under 112. But here...
So what if August 7th of, you got it back from the magistrate in August of last year?
August of 2015, Your Honor.
Okay, and you have 180 days from there?
Correct, Your Honor.
And that's when?
That is somewhere in February, I believe,
Of?
2016. And before that...
Right, when you got, I'm referring to when you got the revised findings.
Oh, the revised finding. I am sorry, Your Honor. The revised finding, I believe, it's not on, it may not even be on the record, but the amended decision was in August of 2016. That's correct.
And so you have till when now? The 180-day clock, you say, starts from that?
Yes, Your Honor.
And
well,
once?
whenever it's supposed to be, there was a amended decision adopted by the board as of January 26, 2017.
So we have a final decision at last?
Yes, Your Honor.
That was in 2017?
Yes, on January 26th.
And is that subject to appeal?
Well, the only pending issue is a matter of whether or not the board will impose discipline, and that is imminent. But the written decision of the magistrate has been adopted with some modifications by the board.
And is that appealable now, or after the discipline has been decided?
I would think it should only be appealable after discipline has been imposed, so
And
that
when
there
will
is a
that be?
complete case.
Is there a limit on when that can take place?
There's no written limit that I am aware of.
Just go on and on and on. This could be gone in a year, or this could, the decision as to discipline is not confined by any rule and as to date?
I would think there'd be there'd be an issue of reasonableness in terms of imposing a time for a final decision, but we haven't got there yet. And as I said, I believe a decision on discipline is imminent. And certainly, if for whatever reason there's a claim that that also is unduly long, that's an issue that can be raised under the normal circumstances on appeal.
After it's final?
Yes,
but
Your
not
Honor.
before?
Yes, Your Honor.
So that could be whenever that happens?
Yes, Your Honor.
Do you agree with the doctor that he essentially is in limbo from the commencement of this process?
I cannot speak to the factual basis of his claim. His claim is that he cannot be paid or is not being paid by insurers. My understanding is he does have a license to practice medicine. So the issue of whether or not he can, or the methodology by which he can be paid, is something that I simply cannot address because there hasn't been an issue that's been factually explored on the record.
Isn't that's troubling to me. You're representing the Board of Registration. There is a claim that the Board of Registration has this rather awesome power to essentially put a professional doctor in limbo, not being able effectively to practice medicine and get paid for it for what is a matter of years, and you're saying you're not aware of the practical consequence of the Board of Registration's action?
Well, it's a question of whether or not on the record before us.
You're the attorney for them. This is not, I assume this would not be unique to him. I mean, how can you be living in a cloud?
No, Your Honor, it's more a question of whether or not the board can carry out its functions in a timely manner with the resources that it had.
But I mean, if we have a trial court keeping somebody in custody for 4 years, we care about that while that matter is pending, and we know the consequence. The person's liberty has been denied for 4 years as the decision is pending. It is troubling to me that you do not know the practical consequences on a doctor of a Board of Registration action where there is a claim that there has been undue delay, leaving this doctor in limbo for, depending on who we credit, at least 3 years.
That's correct, Your Honor. It is, there's no dispute that this has taken a long time. It is by the very nature of the process, because it's in effect a bifurcated process where you go back and forth between the magistrate and the board. The process itself, unfortunately, lends itself to a long period of time to get done, and the nature of the board, because it is a body that only meets on an occasional basis and has limited resources, also is constrained. In this case...
But taking the August 2016 decision, it's been, and I understand the board's made a decision, just not as to what the discipline's going to be. But if you take that August decision, it's been more than 180 days since then.
Yes, Your Honor. Well, although, again, the response to the decision was made in January of 26 of 2017. So that was within the...
Yeah, I think this goes more to the chief's point. I understand it's within the 180 days, but it's still not resolved.
Correct. Correct. No, I understand that there's a frustration by the court because of the length of time that it is proceeding. And frankly, the board in itself is frustrated too. The problem is that we are looking today at a single case, and the board is faced with many, many cases, and it can only do what it can do with the time and the resources that it has, and it is attempting to achieve justice in a timely fashion.
So what is left to do? You've already made your factual determination. Now you effectively have the professional equivalent of sentencing. What is the process for that decision with regard to a discipline to be made?
I believe that there's an opportunity for victim impact statements to be taken and reviewed, and then the board has to convene and decide on whether or not to impose discipline and the extent of any such discipline.
And has a date been set for that?
My understanding is that it will take place either in the April meeting or the May meeting of the board. They only meet once a month. That's part of the problem we have here, because it's composed of volunteer doctors and staff, and they have a large volume of cases to process and a limited amount of time and staff to handle all of them.
Yeah, and so who, may I say, enacts these rules that by which the board operates?
I honestly can't give you an answer standing here, Your Honor.
As you said, the rules very clearly provide, for example, for one recommittal. Who enacted that rule?
I'm sorry, Your Honor, for one?
One recommittal. You said the rule.
Oh, that's under Rule 801. That is that's DALA, the
Rule of what?
the rule for administrative review.
As part of the board's own rules?
Yes, the board adopted those rules for handling disciplinary proceedings.
So these are the board's rules, which the board is free to change, is my point.
Technically, yes. I believe the process was at one point they held more informal proceedings, and there was concern about that, and to allow for more...
I'm sorry, who reviews the rules that the board operates by? Are they subject to review by anybody?
I can't answer the question in front of this court, I'm sorry to say.
Okay, thank you.
Thank you, Your Honor.